right, it's 2 o'clock. I call to order the meeting of the Code Enforcement Board for the City of Tarpon Springs. If you all would please rise, and Tom will lead us in prayer. Open us in prayer.
Father in heaven, thank you for giving us the opportunity to meet this afternoon to discuss common interests and concerns. Lead us to a faithful discharge of the same. In God's name we pray. Amen.
And please face the flag for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Bobby, may I have a roll call, please?
Yes, sir. Mr. Sansoda?
Here.
Mr. Casey?
Here.
Mr. Kramer?
Here.
Mr. Bessie?
Here.
Ms. Archer? Here. Mr. DeMassa?
Here.
Mr. Umsprinsky?
Here.
Mr. Plunkett?
Here.
Mrs. Gass? Here. Please do roll call, sir.
Thank you. It is the intention of this board to promote, protect, and improve health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any agreed party may appeal the final administrative order of this board to the circuit court. Such appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedure this board follows with each case on its agenda is as follows. First, the city presents its witnesses and exhibits, after which the violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the violator is allowed to make a presentation and present any evidence or documents. Then the city can question the violator's witnesses. After both rounds of testimony, both on a part of the city and on a part of the violator, each party is asked to give a closing statement, first by the city, then by the violator. After those 3 steps are taken, this board then closes the public hearing portion of the case to discuss it and take appropriate action. Before we begin the public hearings, we'll have all potential witnesses please stand up and be sworn in by the secretary of the board. Anybody who plans to witness, if you'll stand up and have Bobby swear you in. Anybody who's here to represent themselves.
Right hand, please. Other hand.
Right hand.
Hi.
Got it. It's all right. You're right hand.
Do you swear the testimony you not to give the full truth and nothing but the truth? Yes. Thank you.
And please take the time to turn off your cell phones, or at least place them on silence. And we'll proceed straightway to item number 3 on our agenda.
Good afternoon. My name is Cindy Sanner. I'm the Code Enforcement Inspector for the City of Tarpon Springs. Is there anyone in the audience for 1018 Hamilton Avenue? Seeing none, I'm going to start the photos down. On March 11th, we received an anonymous complaint that there was trash and debris in the lanai and on the side of this house. On March 12th, I conducted a site visit and found assorted household items and trash in the stream lanai and on the side of the house. This property was vacant and it is in foreclosure. The property was in violation of Codes 8-22, the accumulation of trash and debris on private property, and 8-40, duty of maintenance of private property. On March 12th, I sent an email to Adam Jones at NationStar. They're the property preservation company dealing with this property. I advised him of the issues. And then on April 12th, I conducted a site visit and found no change. That same day, a notice of violation was issued and sent to the property owners of record at 2 different addresses that we had on file for them, and also emailed to Adam at NationStar. The document sent to the property address was returned. On May 8th, I conducted another site visit and found no change. On May 9th, a notice of hearing was issued and sent first-class mail and certified return receipt to the property owners of record, and also emailed to Adam Jones at NationStar. The letters were returned. On May 10th, I received an email response from Adam Jones. He stated that he placed a rush order for bids to address the violations. I posted the property on May 30th, and yesterday I conducted a reinspection and found no change. This property is in violation of codes 8-22 and 8-40. I recommend a compliance date of July 1st, 2013, and a daily fine of $25 a day thereafter.
Does the board have any questions for the city?
The fines, do they go to this Adam Jones Land Nation Star?
It'll still go to the property owner of record, and that would be the Mr. and Mrs. Simmons.
Mm-hmm.
What was the main delay for 2 months?
Trying to work with these people trying to get the bank. I knew that there was a bank. They're mowing the grass. They're taking care of the outside, but and in past the pool was a disaster, so they went in and took care of the pool. They put a cover on it. So I gave the Nation Star the opportunity to try and address it, but they're so overwhelmed with jobs. Oh no,
Okay.
no. They've been good in the past, and like I said, it's about compliance. It's about working with people and not pointing them to you and finding them. So I try to gain compliance and give them ample time to take care of it.
Bobby, please receive those papers into evidence.
Would you like me to make a motion?
Yeah. Make a motion.
I move based on the testimony, evidence, facts presented, and law that at the time of the alleged violation, sections 8-22 and 8-40 of the Code of Ordinances of the City of Tarpon Springs were enforced. The respondent has until the first day of July 2013 to come into compliance with the code sections, or a fine of $25 per day shall be imposed each day thereafter that the respondent remains in violation of such code sections.
All right. Any board discussion on the motion? Bobby, if we could have a roll call vote, please.
Mr. Poplinsky?
Yes.
Mr. Damasis?
Yes.
Mrs. Archer?
Yes.
Mr. Bessie?
Yes.
Mr. Kramer?
Yes.
Mr. Casey?
Yes.
Mr. Pansota?
Yes.
Motion carries.
All righty. Item number 6 on the agenda.
This is case 13-800000241. The property address is 331 North Stafford Avenue, and the property owner of record is Lino Sponge Company, Incorporated. Is there anyone here in the audience for this case? Seeing none, I'll pass the photos around. On March 22nd, we received a complaint from a person named Rick. He stated that this property was not being maintained and there was junk, trash, and debris on it, and he said that trucks were parked all over it. On March 27th, I conducted a site visit. I found the property overgrown, especially the rear and the right-of-way along Park Street. There were miscellaneous items stored outside of the business building. There was trash and debris throughout, and there was a trailer cab parked on the grass in front of the business. This property was in violation of codes 8-22, accumulation of trash and debris on private property, 8-40, duty of maintenance of private property, 8-52, nuisance prohibitions, and 57.00, outdoor storage. A notice of violation was issued on March 27th and sent to the property owner of record. On April 15th, we received a call from the realtor handling this property. He stated they were working on correcting the violations. He said that the trailer cab had been removed and the outdoor storage items eliminated, but he needs more time, so we extended it an additional 2 weeks. I did conduct a site visit and found that the front of the property had been cleaned up, but not the rear and right-of-way. There was still trash and debris in the rear yard, but the property was in compliance for code 57.00. On May 13th, I conducted a site visit. The backyard and right-of-way were still overgrown, and there was still trash and debris on it. On May 20th, a notice of hearing was issued and sent first-class mail and certified return receipt to the property owners, and I posted the property on May 30th. On June 10th, we received a call from the property owner. He stated that he was having a dumpster delivered and would cut the grass, but a large tree came down during a recent storm, and he needed a few more days to deal with it. I told him I would still take the case to code board and ask for additional time for compliance. I conducted an inspection yesterday, June 12th, and found no change, but the dumpster was on site. This property is in violation of codes 8-22, 8-40, and 8-52. I am recommending a compliance date of July 1st, 2013, or a daily fine thereafter of $50 per day.
Okay. Does the board have any questions for the city? Hey, Cindy, he said a tree had dropped on the hampering. Has that tree been removed, or is it still a...
It's in the backyard. It's in the rear of the property. This is commercial property. It was in the back where the overgrowth is.
So it falls under one of the things he's already been cited for.
Bobby, please receive those documents into evidence. Oh, you great. Okay, Becky.
I move based on the testimony, evidence, facts presented, and law that at the time of the alleged violation, Section 8-22, 8-40, and 8-52 of the Code of Ordinance of the City of Tarpon Springs were enforced. The respondent has until the first day of July 13th to come into compliance with the code section. That's 2013. Or a fine of $50 per day shall be imposed for each day thereafter the respondent remains in the violation of said code section.
Second.
Any board discussion? Bobby, roll call vote, please.
Mr. Swalinski?
Yes.
Mr. DeMattis?
Yes.
Mrs. Archer?
Yes.
Mr. Vesey?
Yes.
Mr. Kramer?
Yes.
Mr. Casey?
Yes.
Mr. Sansetta?
Yes.
Motion carries.
All right, thank you. We'll just proceed to number 8 on the agenda.
This is case 13-800000382. The property address is 94 South Highland Avenue, common area, and the property owner of record is Tarpon Highlands at Lake Tarpon Sail and Tennis Club 2, Condo Association, Incorporated. Is there anyone representing the property owner? Are you representing the property owner? Okay. Seeing none, I'm submitting photos into evidence. One set of photos was taken on the day that I went out and did the initial inspection, and then the other set of photos was taken yesterday, and you can see it. There's an improvement because it's been raining, so it's not quite as bad now as it was originally. This is a repeat violator. On May 28th, 2013, we received an anonymous complaint that the common area, grass and weeds, were dead, and the area was eroding again, causing sand to end up on the roadway. On May 29th, I conducted a site visit and found that a good portion of the sod or grass was dead in the common area, causing erosion and washout issues. This property was in violation of codes 8-40, duty of maintenance of private property, 8-52, nuisance prohibitions, 134.08, open spaces and preservation areas. As a repeat violator, previous case 10-800000302. On May 29th, a notice of hearing was issued and sent first-class mail and certified return receipt to the property owners of the common area. The notice was sent to 4 different addresses. A copy was also sent to Craig Phoebe on June 10th of 2013 for instructions from Attorney Trask. The property was posted on May 30th, and an inspection was conducted yesterday I found some improvement, to the areas that had grass, but there are still large areas without any vegetation on them at all that are still going to cause washout and erosion. This property was in violation of codes 8-40, 8-52, and 134.08 beginning on May 29th of 2013. I'm recommending a daily fine of $25 per day until compliance is obtained.
Does the board have any questions for the city?
Yes. This is part of the, Tarpon sale and tenant.
Yes.
Is that correct?
It's the center part where there are townhomes.
And it's always been taken care of and always looks so nice.
Did you have a question, Jerry?
Yes. Question as far as repeat violators. I mean, how long have we been talking? I mean, just from your notes here, just the last month, or the new as a repeat violator, the case 10-800000302?
Attorney Trask, could you explain the repeat violator to Mr. Zableski, please?
Okay, the way the statute works and the code of Tarpon Springs adopts the statute basically, to be a repeat violator, you have to have been charged and found in violation of a code provision within 5 years. So it's the same violator and the same code section within 5 years. This being a 2010 case, that would meet that criteria. So, and now on a repeat violation, there's no time to come into compliance. The form motion that you have in your red folder, it's a separate motion so that the fine would begin to run on the date of the inspection. And in this particular case, the code enforcement officer is saying it's May 29th. So if you found them in violation, the fine would begin to run on that date and it will continue to run until they come into compliance.
My concern is that this is a repeat violator and it was for the same thing in 2010. I think $25 per day is a little low. I think it should be higher.
That's your prerogative. That's just a recommendation.
Because evidently he didn't get the message 3 years ago, and it's coming back, so I think it should be more than $25. Sounds like me.
Cindy, do you have any public witnesses that you think would be necessary to hear from?
I guess there's an individual in the audience that would, I mean, she's not a witness, so.
No, hold on a second. Okay. So,
I mean, I didn't tell her to be here, and I wasn't notified ahead of time that she wanted to speak prior to today.
okay, so the way this works, the board knows this is a quasi-judicial hearing. Although it's open to the public for the public to be able to sit, hear, listen, see what's happening, the public does not have a right to speak. The only reason that the public would have a right to speak would either be that the city calls them as a witness, or if the property owner was here sitting at that table, they could call them as witnesses. So the only way they're able to speak is whether or not the city wants them to speak. So
Well, since they're here, I'll allow them to speak, but just know that I did not call them to be here.
Okay. So if you could stand over here, come to the microphone, please. State your name.
And please speak into the microphone so that we can hear you.
Thank you for this opportunity. I appreciate it. My name is Gary Sue Humphreys. I live at 98 South Highland Avenue in Tarpon Highlands 1. I spoke in 2010 in regard to the situation. They were fined $250 a day for a terrible disarray I gave the board, the here Code Enforcement Board, a nice portfolio of pictures that I put forth, and Attorney Trask took them. Soon after they finally complied, which was over 5 months, they laid sod. They attempted to fix the sprinkler system. It worked probably for maybe less than a month, and that's given it some. Their renters, which has always been nothing but rental property, continued to park on the grass and continued to break each sprinkler. Since 2011, that's when they were brought up to code. there haven't been any sprinklers working. Now, all of that beautiful grass that was laid has been gone since 2011. I called Cindy and told her when she posted this little sign on their property, I told her that she needed to make contact with Craig J. Phoebe, who sits as the land trustee of that property, who turned the property over to a Mark Sanders, who is the land trustee. He is the president and remains the president of that, what they call an association. They do not comply to any rules within our development, which consists, including their 14 units, 5 associations, if they want to call theirs association. I have put forth a little portfolio that I would like to give to the board to see, to have, to go over, to make record of what we are dealing with.
That portfolio, you're willing to give it up, you will not get it back.
It is made just for you folks.
Okay.
We need to have the city take a look at that.
But I did give Cindy the information when I called, who in 2011, right after that property was brought back up to code, a new management company, so they called it, is called Rent Solutions. Rent Solutions is run by the same group of people that ran Brooks Loan Properties in the ground, America's Home of America in the ground. Now it's Rent Solutions. Mark Sanders still is the president. Craig J. Phoebe still owns that land, and by the way, owns the land that our 46 units sit on, and I might add, owns the land in the entry of our entire development, and he owns almost all of that land.
Excuse me, I need to stop her testimony right now. Attorney Trask, I need you to review this. I'm afraid that some of the content is inappropriate for this board and has nothing to do with the case at hand.
Oh, but it does.
You're here to find that the property is overrun as a repeat violator.
That's right.
And to establish a fine until compliance is heard, not.
It tells you that Craig J. Phoebe is now a realtor in Newport Richey. It gives his phone number. It's a contact number for you. It shows that Craig J. Phoebe has turned that over to a repeat offender, a fraudulent individual. They haven't paid their water, sewer, and trash to us since 2008. We're in disarray with the city over that. We have suffered in that development like you people have no idea.
Well, I appreciate you taking the time to bring it to our attention just to give us another perspective.
And I might add, he never had to pay a dime of that $250 a day for all those months. Not a dime. And he owes the city money for water, sewer, and trash, and he owes us $60,000. So we're dealing with criminal, fraudulent individuals here.
Okay.
And I appreciate your time.
Thank you for your testimony. Do you want to speak then? Okay, and again, please state your name and address on the microphone.
I need to address this with you when she's done.
My name is Jenny Hardy. I live at 98 South Highland Avenue, Unit 1202. I'm on the board of directors as treasurer. And actually, I'm here 2 weeks ago. I went to code enforcement concerned about TH2 and the way the erosion was. I talked to Sue and Cindy, and Cindy was kind enough to go out the very next day, I think, and look at the property and put a notice on there that, they were in violation. But after going through my records, Sue had said that they were fined, I think, $250 a day, and Mr. Silbeski, I hope that's I pronounced it right. $25 a day is not enough. But I found out that they never paid the $250. Cindy said because they complied, but it took like almost 5 months to comply to that, and I don't understand why the city.
That at that juncture, provided they complied within the time frame that we gave them, they could avoid the fine. But this time, if a fine is assessed, a daily fine, there is no avoiding it. Because they are a repeat violator, they can no longer avoid the fine. If we find them in not in compliance, then they will be fined.
Okay, well, correct me then. As a homeowner, if I get a violation, say May 1st, and I'm fined $25 a day, and I don't, comply until the end of May, don't I have to pay that?
Yes, you do.
Why didn't they have to pay that
if you are a repeat violator? Again, and I'll do this very quickly, but if you were not a repeat violator, if you came here for the first time, and we will say, we'll fine you $10 a day, and we will give you until July 1st to get into compliance. So that's 17 days away, give or take, 18 days away.
Okay.
So that's $180 that you'd end up having to pay if you did not have your property up to code by July 1st. If you did have the property up to code, you'd be okay.
I have you.
Now, the thing is, they came back as a repeat violator. Now, whatever we assess them, starting from May 29th, is a fine that they will have to pay.
Okay.
Do you have anything else that you want to say?
I would like it to be higher than $25.
Okay. Thank you for your testimony.
Thank you.
I'm going to just take a couple of minutes here. Please bear with me.
I we can do it on the record. The documentation that was provided, and I'm going to go ahead and hand it over to you as the chairman. You need to take a look at this. The city has objected to the documentation, and just so that everybody knows what it is, and so the curiosity doesn't kill the cat, is that it basically photocopies of mug shots and criminal histories of a couple of individuals that may have some relation to the properties out there. That is, and as your attorney, that's absolutely not relevant as to whether or not this property is in violation or not. So, Mr. Chairman, you have the obligation to determine whether you're going to sustain the objection, which that would be my advice, sustain the objection because it is not relevant, or you could overrule the objection and receive it in evidence. If you sustain the objection, those documents would be marked as an exhibit for introduction purposes only. It will not be received in evidence, and so the rest of the board should not be, using that or considering that in determining whether the property is in compliance. So you don't have to get a vote. You don't have to have a motion. You make that determination as the chairperson.
No, I find it necessary to sustain the objection. We do need to keep to the matter at hand. That's all that we are empowered to deal with right now. So, Bobby gets these.
That's right. So she'll mark it, but it will not be received into evidence.
Thank you. Okay. Does the board have any questions for the city?
Yes. Is this a home?
No, these are townhomes. This is the common area of a condominium grouping.
So is it a certain person or is it
No, it's the association, condominium association that owns the common area.
And they don't have deed restrictions?
I'm sure they do, but we don't enforce deed restrictions.
Wanda?
What does it take to come into compliance? Sod and sprinkler system?
We can't force anybody to have an operational sprinkler system. We can make them reinstall the sod and maintain it, but there's nothing that says that they have to maintain a sprinkler system. They have to maintain the lawn.
So once the sod is put down,
it's up to them to maintain it, regardless of how they do it.
Right, but I mean, they aren't going to pay a fine for 3 months while they water it and make sure that it's established. It could be The fine.
The minute they lay the sod and I go out and do an inspection, they're in compliance. Now, if that sod dies again,
Right.
they become a repeat violator again. But I also need you to note that there is an outstanding lien against the property. They didn't walk away from paying any fines. There is last year it was quite hefty. There is a lien against the common area for their violations.
Good, because this lady asked, she mentioned that last one wasn't paid. It'll follow them. Yeah. So even if they haven't paid it, it's not going away. But they just have opted not to pay it. Yeah. Okay, thanks.
Well, I have a question then. Based on their past performance, then why is the daily recommended fine just $25?
Because I doubt if we're ever going to see the money.
There's nothing that we can do.
And that's just a recommendation to this board. You can make it the $250 a day. You can, but it has to be. We're talking dead grass. Now, do you feel that that's $25 a day, or do you feel that that's $250? The fine needs to be in line with what the violation is, and it's not.
But
the entire property is not.
Excuse me, go ahead.
No, the entire property, the entire lawn is not dead. There's just a portion of it to the north that is on a hill that causes problems.
Well, also it was pointed out that people that live there are parking on the sprinkler heads. So it's like, gee,
when I've been out there, I've not seen that happen, but it's, if that's what's happening again, we don't care if somebody's sprinkler system is working or not.
Right.
That's not a code violation. And as far as parking, that's all private property, and if you park a car on your front lawn, that's not a code violation. But if you park a trailer or an RV on your front lawn, that is a code violation.
Well,
so if it's a deed restriction that says you can't park in the grass, it's up to the homeowners association to deal with that, not code enforcement.
Well, I agree with you, Cindy, that dead grass might not be as important as some of the other things that we deal with. I think you also have to, though, look at the fact that this group is a past violator as opposed to somebody that had dead grass and then came into compliance.
Right, and understand that my recommendations to you are minimal.
That's fine.
You have every right to put whatever price. I'm just giving you a no less than amount.
I appreciate that. Thank you.
Tom has something to say.
I just wanted to remind the board that the state statute and your code provision says the way that you determine the dollar amount of the fine is you look at three things. You look at the gravity of the violation, how serious actually is it. Then what has the property owner done to bring the property into compliance? And then have they been cited before? So now I'm not saying that it's that clear once you know those three general things, but you should also know that on a repeat violation you can fine up to $500 per day, not $250. So I don't know if that's of any help to you. But
then remember, though, for instance, let's say you kept it at $25 a day. If they paid the fine today, it's $400. So remember, a $250 or $500 fine by the time it gets paid. Go ahead, Jerry.
I just have one. There's no recourse that the city can take against this individual to get our money from 3 years ago or anything.
If I may interject, it is not an individual. It's a nonprofit corporation of the state of Florida. An HOA typically is a 501c. I could be corrected there. But this is an HOA, even though there just happens to be one person in charge of it, or whatever Sundays repeats. So we're not chasing a person.
So tax-exempt organization doesn't have to pay fines?
Not necessarily, but I think that would be important in keeping it in perspective of exactly what the fine is and who's being fined.
They do have to pay the fine. I misunderstood when I was thinking that they had come into compliance, but they hadn't originally.
No, the fines ran until they came into compliance, and there is a large amount owed.
I actually misunderstood that.
There's one other thing. As a rule, we do not forgive repeat violators.
Correct.
It's reducing their thing, and so if you make it outrageous, I would think they might take us to court, because when they come and say, this is $100,000 because you charged us $250 a day, and we say, well, we can't dismiss it because it's a repeat violation. So do they take us to court at that point? And
Well,
I think that's a whole new can of worms.
The first case, where they do still have a lien or a fine, because the 60 days has come and gone for them to ask for a reduction in fines after compliance, that would have to go before the BOC to get reduced. Finding them in violation now as a repeat violator, that cannot be reduced. They cannot ask for a reduction of fines.
But I still think, going up to $250 on dead grass is a little exorbitant.
I don't know that anybody's proposed an increase or what that increase might be, so.
Well, I thought I'd heard that there was.
And remember, whatever fine you all decide, it's incentive. The longer they take to come into compliance, the more the fine accrues. But if it is too hefty, it could push.
And it's not a health safety issue. It's a portion of dead grass.
But there is an erosion issue, though. So,
Mr. Chairman, Cindy, have you had any discussion with them about their willingness and financial ability to mitigate this problem quickly?
I don't recall at least this go around, any conversation with the property owner calling us. In fact, we've sent it to 5 different locations, 3 individuals, so, and we've received no communication from them.
The fine might be minimum compared to the
we had
cost
to
mitigated.
go into Division of Corporations records, public records. We did quite an extensive search, consulted with Attorney Trask, so, we've noticed everybody that we could possibly find that has anything to do with this common area.
They'll have to pass the hat over there and get a few bucks from everybody to afford the sod.
Any other questions for the city? Any other questions? A statement? Okay. Well, that'd be at the discussion portion. Is somebody ready to make a motion?
I'll make a motion.
Okay.
I move, based on the testimony, evidence, facts presented in law, that the respondents were in violation of sections 840, duty of maintenance of private property, 852, nuisance prohibitions, 134.08, open spaces and preservation areas of the Tarpon Springs City Code of Ordinance from the initial inspection date of May 29, 2013, until the property is brought into compliance. A fine of, and this is my own personal thought, of $75 per day is imposed until compliance is achieved, and I'm more than willing to open that up to discussion among my fellow members.
Do we have a second?
I'll second it.
Okay. And Becky, you had a statement you wanted to make?
That's what I was going to discuss, the $25. I wanted to go up a little bit, and that sounds good.
So 75 makes it about $1,200 if they paid it today, which that's not going to happen. I think it sounds pretty reasonable. Jerry, you're shaking your head.
Well, I just find it appalling that the city has no leg to stand on to force this individual or this nonprofit charity organization or whoever to pay the money that is due the city because of a violation 3 years ago.
Well, it's a lien on the property.
Well,
and
a lien on the property has been there for 3 years. We still haven't got a red check.
Yeah.
Now you're going to give them $75 a day for a violation that is reoccurring, and who knows, 6 months from now they lay sod down, no sprinkler systems or anything. It's going to be that way in another 6 months, and we're maybe addressing the same problem. I guess I was raised different. I'm sorry. Somebody sends me a bill, it's up to me to pay it.
Well, it'd be nice to have more teeth in this. The only incentive that we're giving right here as a board is to pay it so that you don't have an exorbitant fine within the next 6 months. The fine that they got hit with before had an end stop. And this fine, there's no negotiation. Wherever the fine is, the fine stays. It'll follow the property. But I wish we had more teeth, Jerry.
That's also quite often where somebody will bring a case before the board and say it's just to establish, so it doesn't have to go through a waiting period, that the next time the person does a violation, it begins right away. And that, that was probably the last time, was hopefully to get an established violation so they can become a repeat violator. We've got other people, it's not just this one association. There are, I don't even know how many people have outstanding fines due to the code, to the city on other code enforcement issues. It happens. It follows them, it'll leave them in the end. So, I'm okay with that.
I have some discussion I'd like to add. I'd like to remind all of the board members that as a violation, this is barely on the radar, and typically we do not even hear violations for dead grass. I should also remind all the board members that it's a very strict rule that no one is allowed to water more than 1 day a week, and we cannot fertilize during certain months of the year. And anyone that attempts to comply and keep a lawn alive on that knows that it almost doesn't work. And those that have green lawns because they overwater. So, just to keep it in perspective, it's not the entire dead lawn. We have a section of lawn that is dead. Some. And if we're going to apply that rule, we would have to be pretty even-handed. That means that we're going to have to apply the same standard to everyone that has a section of dead lawn. Now, it's valid, and we, unfortunately, yours has nothing to do with this that's at hand. In addition, we allowed some ladies who have a very genuine concern introduce a whole bunch of information, frankly, that has nothing to do with some dead lawn. That issue has to be addressed in a different place, in a different form. I'm just kind of concerned about setting a precedent, about taking a big old whack at someone over some dead lawn. That's not trash, it's not a pool, it's not overgrowth, it's not a fallen tree, it's not an abandoned car. It's just a section of dead lawn.
What about the washout and erosion?
I saw those pictures and I didn't see any washout. I saw a little bit of sand on a sidewalk.
Well, then I guess maybe we should question our inspector that apparently came. Somebody wrote it up. I didn't write it up.
I think Inspector Santa was attempting to do her best in a
If you look at the photos from the first visit when we got the complaint, there was a little bit of sand on the roadway at the bottom of the hill. Someone put some railroad ties at the bottom of the dead section, which I don't know how good that's going to be, holding back any sand to keep it from going on the roadway, but when I went out there the other day, there was there was no sand on the roadway. Now, whether the other HOAs have been sweeping it up or, removing it somehow, I'm not privy to that. But, again, it's a section of grass happens to be on a hill that when you get a heavy rain, the sand's going to wash out, as it does everywhere in Tarpon Springs. It is what it is. It's not undermining anything at this point. It might be undermining some of the porches on that property, but that would be up to the individual homeowners or townhouse owners to deal with that.
Mr. Chairman, I suggested call for the vote.
Is there any more talk on it? I appreciate you having the guts to say what you said, Justin.
Hey, I'll tell you what, excuse me, I didn't mean to interrupt.
Yeah.
But what he just said makes me realize that I could be fined. I have dead grass, and in the neighbors' yards, they never made my neighbors do anything about the runoff from their yard. My neighbor has to shovel out her garage every time we get a rainstorm. That's erosion. And, I'm not going to vote for this. I just think we're talking dead grass, and everybody has it.
And that is actually what we are looking at here. you have to put your individual, opinion aside, and you have to just focus at the matter at hand. If we look at these owners as individuals and use their attitudes and as reason for the fine, I think we could get awful upset and awful heavy-handed with the fine, but we have to realize, and I appreciate the perspective that you have given us, Justin, and Jerry, I appreciate you opening this up as well, because it is irritating that there's a fine outstanding and there's nothing that we can do about it. But I suppose if the talk is over, then we'll vote, and if the $75 a day is shut down, then we'll just open it for another motion. So at this point, Bobby, will you give a roll call vote, please?
Mr. Kowinski?
Yes.
Mr. Mr. DeMontis? Sorry.
Yes.
Yes, thank you. Mrs. Archer?
Yes.
Mr. Vesey?
No.
No.
Mr. Kramer?
No.
Ms. Casey?
No.
Mr. Santos?
No. Okay, motion did not carry. So I would like another motion, if somebody is willing.
It could.
Someone has to make one, else we don't leave.
Well, I, make a recommendation that one of the four no's, since they didn't like the $75 fine, one of the four nays would go ahead and make a motion with some kind of fine,
I will.
even if it is
Okay.
a fine.
All right.
Okay.
Wanda?
I thought I saw page.
Second page.
Second page. In the red page.
It's not the page I want. All right, I move based on testimony, evidence, facts presented in law that the respondent was not in violation. That's my motion.
Do we have a second?
I'll second that motion.
Any board discussion?
Totally disagree.
Bobby, a roll call, please.
Yes. Mr. Kowinski?
No.
Mr. DeMontis?
No.
Mrs. Archer?
No.
Mr. Vesey?
Yes.
Mr. Kramer?
Yes.
Mr. Casey?
Yes.
Mr. Santos?
No. All righty. How about, hey, I'm going to pass the gavel, okay, and I'll make a motion. And we'll try this again. And I move based on the testimony, evidence, facts presented in law that the respondents were in violation of sections 8-40, 8-52, and 134.08 of the Tarpon Springs City Code of Ordinance from the initial inspection date of May 29 until the property is brought into compliance. A fine of $25 a day imposed until compliance is achieved.
I'll second the motion.
Any,
No, you passed the gavel, so
Oh,
Wanda's gonna
sorry.
hold it.
All right, there's been a motion and a second. Is there any discussion?
Excuse me, who was your second? I'm sorry.
You could pick anyone, because I think everybody did it, but,
Okay. Okay.
Is there any discussion? Okay, Bobby, would you please do a roll call vote?
Okay. Mr. Kowinski?
Yes.
Mr. DeMoffice?
Yes.
Mrs. Archer?
Yes.
Mr. Vesey?
Yes.
Mr. Kramer?
No.
Okay. Mr. Casey?
No.
Okay. Mr. Sansetta?
Yes.
Motion carries.
Motion carries.
You can keep that down. All right, affidavits of noncompliance. Case, 12-200000033, 1310 East Tarpon Avenue. Is there anybody in the audience to represent this property? Patricia Zapp. Case number, 12-200000034, 1306 East Tarpon Avenue. Is there anybody in the audience for this? Michael Potsrowinski. Finally, case number 200000013, 712 Lincoln Avenue. Anybody in the audience for Lincoln Avenue? Marilyn Murray. Can I have a motion to accept the affidavits of noncompliance, please?
I move that we accept the affidavits of noncompliance in case 12-200000033, in case 12-200000034, and in case 13-200000013.
Do you have a second?
Second.
All those in favor, say aye.
Aye.
Opposed? Motion to accept the affidavits of compliance, please.
I move we accept the affidavits of compliance in case number 0200000249, case number 0580000704, case number 10-200000099, case number 11-800000880, case number 12-200000026, case number 12-800000509, case number 12-800000970, case number 13-200000015.
Do we have a second?
Second.
All those in favor, say aye.
Aye.
Opposed? Motion carries.
Excuse me, I apologize to interrupt. I'm here in regards to one of the affidavits of compliance at 1221 East Lime Street to address a lien, and I'm here actually to see if I can get that reduced. Would it be the appropriate time to address it now, or would we wait to another? I didn't see it on the agenda.
It's not on the,
That's a reduction of
Number
time.
20.
all right.
20?
We haven't got there yet.
Yeah,
We're not
but
there
stay
yet.
there because that's where we are now.
Perfect.
You're representing 1221 East Lime Street?
Well, then I suppose it would be the perfect time to address it, yes.
Okay, good.
But I would remind the board, you do not take testimony. You will not hear from her. You make your decision based solely upon the written documentation. If you have a question, you can ask the question, but you will not hear from her. She will not testify. If you have her ask a question, we'll swear her up.
Okay.
If there's no questions, she's just moved up just to here.
All right, so item 20, agenda item 20.
Okay, well, Cindy's not going to tell you anything. You've got the documentation. You would have the petition. You would have the city's response.
Does everybody have that? It came with the package Cindy gave you earlier in the week.
Yep. I'm afraid that I don't have mine. Perhaps I could
All right,
use someone else's.
Thank you. Request for the reduction of fine. On the second page, the city's response, circumstances surrounding the disposition of the above property found it to have been brought into compliance. We have no objection to any fine reduction that the board finds appropriate. Cindy, are there any city
This isn't my case, but,
okay.
excuse me, Sue just wants to find Gary Sherman.
Okay.
How much is the fine?
Yeah.
$41,100.
And how much, what would the administrative cost be?
Any idea what the administrative cost would be?
This is that
Typically,
hookup.
minimum administrative costs for code enforcement are $250, so I would think that this would apply as well.
Okay. I don't know if everybody's read the letter, but this isn't a case where the grass was overgrown. This was a hidden thing, and I think that we ought to bring it right down to the administrative cost.
No, this was a mandatory connection.
Right, but isn't this back where they went through and everybody had to hook up to the...
Right.
Okay, but as I say, it's not like it was, fallen trees in the driveway that were making the neighbors. This was just something that the institution that now is faced with that
Well,
fine.
the whole thing is, though,
Hold on a
everybody
second,
was given...
Cindy. She didn't have a question for you. I know you want to speak, so if you speak, we need to let her speak, and let's just wait for a question.
Well, I guess I don't have a question.
Okay.
My statement is that the homeowner, as I say, the people who are in possession of this property now
Are not the
they're never going to
violator.
sell that house if they got a $41,000.
Yeah.
Well, then too, the people that are responsible for the house now, it appears from this letter, got their ducks in line within several weeks.
Minutes.
Had
No.
all the work done, completed, so I'm in agreement with you that it should be lowered to
Right.
whatever administrative cost might be, $200-300 or whatever.
And once this institution found out about this thing, they acted
Yes,
quick.
they did. So
I'm
I'm
impressed.
giving them all the kudos
Yep.
possible.
And if we, I think it would discourage somebody from acting so quickly if they don't get rewarded for doing that.
Right.
And as I say, it wasn't an eyesore. It was just something that had to be done, and the people that were responsible for doing it didn't do it. And
Cindy, I saw Sue come and whisper in your ear. Does the city have any representation on this right now? Or is she still looking for somebody?
She can't find Gary, so they're trying to locate him, but...
All right.
But he sent a letter saying he has no problem with reducing it.
Yeah.
Now, I know that we're about showing hardship, but I just don't think this has anything to do with that. I just think it's about
Yeah, as soon as
these hookups that...
who owns it now, Federal Home Loan Mortgage, and once they became owners, if I'm to understand it, they jumped on this and took care of business. Is that correct, Cindy? As soon as...
Again, this
Okay.
is not my case. I
That's
have
all
no
right.
knowledge of any of it.
No problem.
I'll make a motion if you'd like, Mr. Chairman.
Okay. Any other board discussion? Okay.
I move that the fine of $41,100 in the case of citation number 10-200000099 be reduced to the amount of $3,500. This reduction will occur upon payment of the stated reduced amount if paid within 60 working days of this order. Failure to pay the reduced fine will result in the original amount of $41,100.
Do we have a second?
I second it. 35, you said, sir?
3,500. Board discussion.
Is that what it costs?
Administrative cost.
Is that administrative cost?
It's simply a guess. We don't have the administrative cost. I imagine the administrative cost would be less. I would guess the administrative cost would be $1,000 or less, I would imagine, but... Well, administrative cost is at least $250. Administrative cost could go up to anything, depending upon how much time was put into this.
Well, my guess is what this is about is it's not in compliance until they get word that it's been hooked up. So I don't see a lot of difference between somebody inspecting. I think 3,500, when it's probably a lot closer to 500 than 3,500.
Unless, of course, that septic system was faulty and was befouling the water in the ground for the last 2 years while it wasn't hooked up.
This is the whole, I see what you're saying, but this is the whole city that got hit with this. But again,
Or it was that particular area that got, I mean, there's a whole reason that we are getting rid of septic systems is that, you know, they can be producing a lot of waste into the groundwater. There could be a lot of damage from this that we don't know about.
But I think a lot of people, you know, in the city, I recall that the city went out of their way to make it easy for people to tie into this, but it still might have been hard for some people to afford that. With this economy, and I just think that...
If you have questions for him, we need to swear him in.
okay. Mr. Sherman, would you be willing to represent the city for this case? Bobby, would you please swear him in?
Do you swear testimony about to be the full truth and nothing but the truth?
I do.
We understand that Federal Home Loan Mortgage is the current owner, and as soon as they took title, they took care of the violation in as expeditious a manner as possible. Is that correct?
That would be correct. Can you speak into the microphone, Jerry? That's correct. Okay.
Do you know, is there any administrative cost that the city incurred with regard to this case?
Not that I would be aware of, no.
Okay, so it would be safe to say then that $250 administrative cost would definitely cover anything that the city was faced with.
I would agree with that. It would be a matter of time that I have involved.
Okay. Does the board have any questions for the city?
Okay.
Based on his testimony, would you like to modify your...
No, I would not.
Okay. Then, Bobby, if I could have a roll call vote on the motion as it stands.
All right. Mr. Koblinski?
No.
Mr. DeMontis?
No.
Mrs. Archer?
No.
Mr. Vesey?
Yes.
Mr. Kramer?
Yes.
Mr. Casey?
No?
Mr. Santos?
No.
Well, sure.
Okay. If we could have another motion.
I'll be happy to do that.
I'd like
Thank you,
to make a
Wanda.
motion.
Wanda already
That's
spoke
okay.
up. I'm
Oh,
sorry.
that's fine. No, let some of the new kids do them.
Go on,
See
new
how
kid.
bad I messed it up. I'd like to move that the fine of $41,100 in the case of a citation number 10-0000099 be reduced to $250. This reduction will occur upon payment of the stated reduction amount if paid within 60 working days of this order. Failure to pay the reduced fine will result in the original amount. Did I read the right one?
You did? You did a good job.
Second.
Any discussion on the new motion? Okay, Bobby, if we could have a roll call vote, please.
Mr. Koblinski?
Yes.
Mr. DeMontis?
Yes.
Mrs. Archer?
Yes.
Mr. Vesey?
Yes.
Mr. Kramer?
No.
Mr. Casey?
Yes.
Mr. Santos?
Yes.
And you know what? I have a feeling that that'll be paid.
Thank you very much for your time.
Thank you.
Was a chance to pick up a few bucks for
That's not a job, Bruce.
All right, we'll move on to the approval of, oh wait, no minutes. Guys, we're still in session, if you don't mind. Is there any public comments, any comments of the board right now? Wanda, board comments, anybody?
I'd like to know how Tom Taft Jr. is doing.
Tommy just got promoted to sergeant last week.
Yay!
So,
Congratulations.
my 22-year-old son is now a full tank commander. He's 5 soldiers work underneath him, but he is a tank commander for a Bradley fighting vehicle. So,
Wow.
he's at Fort Benning. All the tanks came down to Fort Benning.
Okay.
Yeah.
Nice.
So So anyhow, thanks for asking. Really proud of you.
I'll say congratulations.
Okay.
And if it applies, happy Father's Day. And happy birthday to our Army. Tomorrow will be the Second Continental Congress in 1775. So however many years that is. And then Flag Day, 1777, Second Continental Congress adopted our flag. So
238.
238. Happy birthday, Army. All right.
Happy birthday for our inspector.
Of course it is, yeah. How did you guys know that? My computer reminds me.
Happy birthday.
Happy birthday, Cindy.
Yeah, great. You're not supposed to wish them a happy birthday after, 19? You're at at least 23, 24.
I do have one other thing.
Okay, Wanda has a comment.
At the last meeting where that young man from around the world, I was so tickled that he loved our city that much. And this week, I read in the newspaper that the city of Tarpon is not going after BP for 1 cent because they don't feel we were damaged, and I love that. Everybody's got their hand out, and everybody's lawsuit crazy, and I am so impressed with this city to not be one of those people.
God bless Tarpon Springs. Cindy?
I just want to take this opportunity to thank all of you for volunteering to be on this board. I know that I got a kick out of today's meeting. I like it when there's, a disagreement and you agree to disagree amicably, and it's what the whole government process is all about, different points of view. So thank you for your time. Thank you for being civil to each other on this board, and you're a great group of people. I'm very, very proud to have you as my code board member.
That was nice.
Okay, well said. Okay, Becky?
I'm sorry.
I'd like to wish everybody a happy 4th of July, and I'm so glad they're having fireworks this year.
Yeah.
And I don't know if I'm supposed to say this, I will not be here the next month.
Oh.
Okay. All right. Well, that's a point against you. Thank you, Becky.
I have a comment, if I may, Mr. Chairman. As a board, we are a real dichotomy. For many, many, many times, we have argued in the past to give the city more than their minimum money for their efforts. And today, we voted for $250, which is barely enough to cover the costs. And there was more money available to help the city with a few more dollars. But for some reason today, we decided on $250 was plenty. And in the past, we've argued against that many times and voted to reduce fines, but reduce them to numbers that are in excess, at least double, triple, 4 times the minimum city money. And my comment is we're just all different. We change monthly.
I'd like to make a comment in response to that. We had a Tarpon Springs officer, an official of the city, come in and said he didn't think there was anything about it. Had his testimony been different, I think your position could have been supported, and I would have voted for your position.
Well,
however, I'm only saying I voted the way I voted because we have a witness come in here, okay, who we have to give him some credit. He works for us. He works for the city. And he says, I don't know, nothing. Okay? It's hard to then say to justify $3,500 or $35,000 or $350 in light of his testimony.
I didn't want to open an argument. I'm not disagreeing with you. What I'm saying is that we're all different here, that every month we change our position on a lot of things. Because
I personally think that won't happen if we get a witness to come in as the city establishes a figure, administrative figure, and testifies to that fact, so that there's a record and a transcript, okay, that'll reflect this is what the Tarpon Springs administrative costs are.
There's little doubt in my mind that your motion would have passed had he not interjected.
And that's fine.
I like the dichotomy that you're.
I'm not defending myself. I'm making the statement that we just, in that regard, a fine reduction, we have never been consistent.
Well,
And
we're
we've
not-
always argued among ourselves, and we've always wondered, even if there's grounds to do it, and we over the years have forgotten to read the documentation that describes what the grounds are for fine reduction. I'm not sure this one even met those
What's
guidelines.
nice is, we definitely look at these things on a case-by-case basis.
Yeah.
There's no doubt about that.
I think what y'all have to remember too is it's not just myself or someone else going out and doing inspections, but it's Sue answering the phones and writing up the complaints and doing the courtesy letters, notice of violation, notice of hearing, making sure everything's mailed, filling out certified return receipts, dealing with sometimes very nasty people on the phones, keeping all the files straight, preparing the agenda. Without her, I couldn't do diddly squat. I mean, she is just invaluable to what I do. I go out and take a look at the complaints or find, proactive here and there and, deal with the sponge doc. That in itself is a full-time headache, but, I certainly could not, do it without Sue. And again, those are the administrative costs. You're talking my time, her time, more her time. So that's why the $250 is basically our minimum amount for. Sometimes it exceeds that, depending on the amount of mailings that went out or the amount of re-inspections I did, or that's what it entails.
I just want to let the board know that the city of Dunedin just went through the same process to determine what their administrative fine is. Their administrative costs are $1,200 a case.
Wow.
So I think that you're way underestimating when you take into consideration your time and Sue's time and your postage and the use of the police facility, the use of the phone system, electricity, telephone, you name all that kind of stuff, and that's what Dunedin did. $1,200 a case.
Well, then, had Tom spoken, you might have passed anyway.
I just thought you would it's just an interesting,
Well,
maybe that should be reviewed by the city.
or actually, you guys can take that and consider it in reviewing future cases.
All right. I have one other short comment. I want to congratulate my esteemed colleague on the left here for his point about brown grass. I was in 100% agreement with him that it's pretty damn hard to find people on brown grass when we all have it.
Yeah, I was totally going a different direction, and we're not supposed to be doing this talk.
And my big concern with those folks is, can they even afford to mitigate the problem?
Annie.
Yes. I would just like to say that as we were talking, certain circumstances bring on certain changes, as it did when the gentleman spoke about the cost. Also, I looked at, I don't think we're looking at the cost. Are we really looking at the cost of what this board bring in for fines, or if these salaries are already in the budget?
The salaries are already in the budget. We're not here to make money. We're here to change violators, bring violators into compliance.
Right.
And
sometimes the circumstances is not going to always be in favor of the city, because sometimes citizens have our needs. And I think that when we look at overall both the citizens, because we are the people. That's all people. And I also want to comment on Justin, his perspective, because I'm sitting here thinking, does the city really have a code enforcement against brown grass? I mean, with the restrictions that laid out, is there really a code in there saying you can't, or was the question really about the receding of the sand rather than the brown grass?
Okay, I'm going to stop right now this conversation. This case is still pending. We really shouldn't be talking about it while the case is still... The code provision is property maintenance and lack of property maintenance. So...
Yeah. Anyway, with regard to the cost of the city, if if a case is brought into compliance before the fine is, levied, then there is still a cost to the city that they aren't reimbursed. And so, any other, comments, and thank you. Okay.
I was gonna redo it for an hour.
I said hi to Mr. Haig.
That's a little brown nosing going on over there.
All right, it's 3:15 and our meeting stands adjourned. Thank you very much.